Petitioners against implementation of the Finance Act 2023 say the High Court's ruling that postponed the effective date of the decision on the illegality of the Housing Levy until January next year is a plot to give the government more time to enact a comprehensive legal framework that allows the unconstitutional housing tax to remain operational. The pro-government side in the case led by Attorney General announced that it will appeal the High Court's judgment, which declared the housing levy unconstitutional, despite being awarded a 45-day stay to continue collecting the house tax. Seth Olale followed the heated proceedings at the Milimani Law Courts.
In declaring the housing levy unconstitutional, Justices David Majanja, Christine Meoli and Lawrence Mugambi said the housing tax lacks a comprehensive legal framework and that imposing the levy against persons in formal employment to the exclusion of other non-formal income earners without justification is discriminatory, irrational, arbitrary, and against the Constitution.
And in violation of Section Articles 27, 201, B1 of the Constitution.
The respondents in the case, including the Office of the Attorney General and Kenya Revenue Authority, sought a stay order of 45 days, saying the Ministry of Housing needs time to suspend contractual agreements with suppliers.
You're asking for
a stay or a conservatory order for 45 days as regards the portions of the decision that has aggrieved the respondents.
A request that was granted by the three-judge bench of the High Court after a 2-hour break.
And these orders of stay shall remain in force until 10th of January 2024. Those are our orders.
Petitioners who sought to have taxpayers refunded the housing levy for the 5 months the illegal law has been operational, termed the High Court's ruling deferring the effective date of the High Court's judgment on the housing levy until January 10th, 2024, a plot to give the government more time to enact a comprehensive legal framework that will grant validity to the contentious housing tax.
Kwa kusema kweli ni inamaanisha ya kuwa wanaendelea kukata ile pesa kutoka kwa mishahara ya wafanyikazi.
Is to actually render any proceedings that are going to be held in the Court of Appeal as moot and academic, because already the court has granted far-reaching and unusual orders of stay of execution. So in a sense, the court has given with one hand and taken with the other.
The pro-government side stating that it will appeal the High Court's judgment, which declared the housing levy unconstitutional, despite being awarded a 45-day stay to continue collecting the housing tax.
Tomorrow we will be filing the notice of appeal and possibly an application for a stay of these orders or a conservatory order from the Court of Appeal.
The court also saying Section 76 to 78 of the Finance Act 2023, amending Section 7 of the Roads Board Act, Section 87, amending Section 28 of the Unclaimed Asset Acts, and Sections 88 and 89 of the Finance Act, repealing Section 29 of the Finance Act, repealing Section 29 of the Statutory Instruments Act, are null and void. The 45 days stay order issued by the High Court means that Kenyans will continue to tighten their belts, especially heading into the festive season, despite the same court earlier on declaring that the current implementation of the same housing levy unconstitutional. Seth Olale, Citizen TV, Milimani Law Courts.